I'm Jackie Garrick. I'm the founder of Whistleblowers of America. Most of you know me. We do these roundtables every month as a way of providing community engagement and peer support. It's a way we connect through each other. That's why I was mentioning a little bit earlier about using the chat as a way to have dialogue with each other, ask some questions, share resources. It keeps us active and engaged. As many of you know, Whistleblowers of America, we just finished our annual conference in September, and we're working on getting all of those videos and all that finalized. I know, oh good, Jason is here. And we've had lots of questions about just being able to view those. They are up and running, coming. We have done our own campaign, our what we've been calling a 6-word story. For those of you who maybe have a journalistic background, you may know the story of Ernest Hemingway being asked to tell a story in 6 words, and he said, "Baby shoes for sale, never worn." So we thought we can redefine the word whistleblower in 6 words. We're trying to call out the Merriam-Webster dictionary editors to look at this common use terminology, because they use some very negative terms for whistleblower in their synonyms. So if you're in your, on your computer and you're typing away and you type whistleblower, you hit the word synonym, you get some very negative connotation type words, as opposed to the more positive ones that we all think would be better choices. So that's our latest campaign. We're asking people to record their own 6-word story and email it to us. You can see the campaign on the website. It's on social media. And we're very excited that we've already started to get people responding and sending us some videos. The idea is the more we send videos, the more we send this out, hopefully the more the dictionary people will be paying attention. And of course, Paul just put the 6-word story link in the chat. So if you don't know what I'm talking about, you can find it there and you can do your 6 words. It can take you as little as 10 seconds to record a 6-word story. So we're asking people to do that. And then, of course, I'm not shy about plugging my own materials. My new book just came out. Oh, I've got it on blur. My Be a Giraffe book is brand new. It's for young people to learn about business ethics. That's on Amazon. We had a great illustrator come in and illustrate the book. She won an art contest. June Bellamy from South Africa helped write a meditation. So if you can, the Be a Giraffe, which Paul also just posted in the chat, I love Paul, is now available. And the money we raise, of course, is going back to Whistleblowers of America. So you're getting a book and a donation all at the same time. So please consider looking at that. So again, say hello in the chat, introduce yourselves if you would like. And I'm going to go ahead and start to introduce this panel and this topic. A Freedom of Information Act request, a FOIA, is what we have the experts here tonight. Kel, Michael, and Jason know far more about FOIA than I do. As a whistleblower myself, the one thing I can say is that as I was blindly hunting and pecking my way through the whistleblower process, and I was getting crap on Discovery. I was getting like, "Are you free on Tuesday? Can we meet on Thursday?" kinds of emails, just troves of that is what they gave me in Discovery. And I knew that just couldn't be right. So another whistleblower told me, "Well, do a FOIA." And I thought, well, I don't know anything about FOIA. And so I really had to figure that out for myself. I did a FOIA, and I will never forget the day in June when this package arrived and the nastiness in those emails was what I was able to present to the judge. And I think it was really just reading 2 emails that convinced him there was animus. And I won my case. This is an important tool that I think is highly misunderstood, not well utilized, and I think we could do a better job of explaining FOIA. I'm not the person for that, so I'm going to actually turn it over to Kel. I'm going to let him introduce himself, and then Michael and Jason, I'm so excited that you're here as well. So we have lawyers and journalists. So I think you're going to get to hear a broad explanation about FOIA tonight. So Kel, go ahead.
Well, thank you for having me here. I'm Kel McClanahan. I am a lawyer, as Jackie said. One of the things that I do primarily is FOIA and similar avenues to getting records. I specialize in national security stuff. The executive director of a nonprofit law firm called National Security Counselors. And I also teach a class at George Washington Law School called The Law of Secrecy, where we hit a lot of this stuff as well. And I'm here to talk about sort of what I wish every potential client would know sort of before they come to me with a FOIA request that has problems that I would then have to sort of try and fix. And with me, that Michael introduce himself, a longtime colleague, someone that I've worked with for many years, and I'm glad he's here.
Hi, it's a pleasure to be here. And another thing about Kel is he actually litigated our most successful FOIA case and got 13 million pages of documents out of the CIA as part of the release of their CREST database. Very grateful for his work there, and he is the person I turn to when I get questions I'm not quite sure what to do with. I'm Michael Morisy. I'm the co-founder of a nonprofit called the MuckRock Foundation. We have helped file about 140,000 public records requests, including both federal Freedom of Information Act requests, as well as requests at the state and local level in all 50 states and I believe all of the territories as well. We build tools for journalists, we build tools for researchers, we put on trainings and webinars, we run software, including other services like Document Cloud and NoTranscribe. But one of the things I was really drawn to about public records was the fact that this law is open to everybody. It doesn't matter who you are. You can be a journalist, you can be a researcher, you can be somebody who just knows or suspects something is going wrong within your community. And that just seems like such a beautifully democratic, small d democratic law in terms of the people are in charge and the people are in charge of government, and everybody has the right to kind of ask what is going on. So it's something I was always really, really excited about in terms of not just enabling reporters to do their jobs, but whistleblowers, the public, everybody else has this really wonderful right. And I've learned a lot also from Jason, and I'll pass it off to you.
Hi, everyone, and thanks for inviting me over to this discussion, Jackie. I appreciate it. I've known Kel and Michael for, God, many, many years. And when you're in, there's regular time and there's FOIA time. You know, regular time is like, wow, you know, I can't believe it's been 20 years. And FOIA time is, oh, it's only been 20 years. I'm going to wait a little while longer. So I'm a journalist. I'm an investigative reporter. I work at Bloomberg News. I've been there for about 2.5 years. I aggressively use the FOIA, the Freedom of Information Act, as the basis for much of my reporting. And I publish a FOIA newsletter that I started about 7 months ago called FOIA Files, where I obtain records on a regular basis, and I, try to make use out of it. I'm kind of notorious for that. I like when I get records, I want to share them with the public. I don't want to just hold on to them. And it's always been it's sort of like, I'm a vegan, but I'll equate it to kind of like eating the entire carcass. Like, just don't leave anything behind. I like to put it all out there. But I also like to make FOIA fun, particularly when discussing it, which is, I think, really, really important because, you're going to battle against the government. And I, personally like that fight. I love going to battle with them and trying to figure out what I can get. And when they say no, I love that, we have the opportunity as journalists, at least, and the public does as well, to, to appeal, to say, go back and search again. I don't think you did a good job. But one thing I do want to note, while we're discussing this, is that the FOIA itself, I would say, at least in my experience, maybe the past 10 or 15 years, but I'll say 10, has become really, really, really popular. And you can see that in the annual, reports from the federal government about the number of requests that they're getting, right? So they get, 1 million requests across the federal government. And now I'm only talking about federal. State is different. Every state has its own public records laws. But on the federal side, they have all these requests. They don't have, they haven't added more people to process those requests. So the requests linger in this backlog and can stay there for years and years and years and years. So how do you combat that? One thing that is really important is to know what you are looking for, to be very, very specific and targeted. I'm a person who in the past has gone on many fishing expeditions. I don't really, I don't advocate that or suggest anyone do that these days, because you'll never get anything, or, you'll start living in FOIA time, and, you don't want to be there. But anyway, that's sort of a long spiel that I have. Always great to see Kel and Michael. And they are two of the greats in this area. So good to be chatting with everyone here.
All right, so let's get to some of the nuts and bolts of what is a FOIA, what do lawyers need to see, how do you write a FOIA, different agencies, different requirements. I know I did when I did a FOIA for the DoD, and then I did one for the VA, and they were very similar. Asking about some of the same people, the same verbiage. What I got from the DoD, I got 250 blank pages from the VA. So I was like, how did one agency send me all of this that was a gold mine, and one agency gave me blank 250 pages of blank paper? So can you explain that? And are there fees to do a FOIA?
I'm going to hit one thing very quickly first that Jason said that I think is going to inform all of our discussion, and that's our joking about how long we've known each other. That's a whole thing that anybody who's even thinking of dealing with FOIA needs to know. FOIA time is a real thing. I'm in briefing still at the initial district court level for a case that I filed in 2013 for Jason's 2 times ago employer when he was there. And we're still in litigation over probably about 500 pages. FOIA requests are not speedy. You don't file a FOIA request if you need information for a hearing or to make your case in 6 months. You file them, whenever you can, knowing that you may not get the records for years. And 7 months, Jackie, you're talking about in the chat, 7 months is fast, honestly. And Michael can tell you it does change from agency to agency. I've got another agency that says I'll get you what you need in 20 days, and they mean it because that's a decent office. I've got "Are you still interested?" letters coming from DIA to request that I filed in 2011 that I have yet to get. They have not even processed yet. They haven't even gotten to it. So that's what we're talking about when we talk about FOIA time. Now, as far as how do you file a request, as Jason said, it's pretty easy. That you say, I'm interested in these records. Sometimes if you know exactly what you're looking for, then yeah, you say, I'm interested in the report that was written on date so-and-so about topic so-and-so. Other times you don't know what you're looking for. You're looking for all records about me, all records about the fire that happened on October 11th, 2018, because that's what you were a whistleblower about. You get sort of these micro fishing expeditions. You don't say all records about stuff, but you say, I want a lot of records. I don't know what you have. That's part of the reason why I'm asking for this information, but I can tell you enough. And then they have an affirmative duty to consult with experts and find out what records do we have about this topic? Where would they be? What office would they be in? Agencies are variable in how well they do that, but they're supposed to. And this is true for federal FOIA. It's true for state and local stuff. And Michael can talk about doing that because that's his area of expertise. But, all it really takes is a letter. It doesn't have to follow any particular format. Michael can't pitch it for himself, but I will encourage everybody to go to MuckRock. They have a FOIA request engine where you type in who you want to go to and what you're asking for, and they'll sort of format it for you and allow you to send it off through them. It's a huge time saver for people who are especially amateurs.
Would
And
you mind putting that in the chat like that? I didn't quite catch how to spell that.
yeah, it's just that MuckRock. And
Well, thank you.
they have like creative FOIA requests, and you can go and see what other FOIA requests have been filed with that agency, and see sort of how they play out. Should I do certain things? Should I not do certain things? It is ostensibly free, a little bit. You're entitled to 2 free hours of searching and 100 free pages. If you're news media, you're entitled to free searching and 100 free pages. If you're what's called a commercial requester, I'm looking for information I'm going to use to make my company better, or I'm going to get the contract that you have with my competitor. You're charged out the nose for everything. And if you're educational or scientific, you're a student, you're a professor, you're doing research, then you're allowed the same as news media. Most people here would probably be the all other, which is the 2 free hours of search time and 100 pages free. After that, they can charge you. Some agencies are good about it. DoD says we don't charge for duplication fees because everything's electronic and it's stupid. Others will insist that they must charge you 50 cents a page for things that are released to you in a PDF on a CD. So it's all over the map. But the one important thing that I'll get to, then I'll let Michael take over for sort of his take, is where you send it is almost as important as how you write it, because the rules are very, very strict, and courts love this. They love to get rid of cases on this. Every agency, at least federal agency, has a FOIA office. They are required by law to put a link to FOIA at the bottom of their website. If you send it anywhere else, they can ignore it. They can throw it in the trash. You have to send it to the FOIA office. And you can also, if it's about yourself, your whistleblower, you want to ask about records they have about me, how mean they were to me, you can also use something called the Privacy Act, and they have to do both of those. We can get into that in more detail later if y'all want to. But write a simple request, like you're asking for something, like you would go to a reference librarian and say, what books do you have about dinosaurs? That's sort of what you would do. You write a letter version of, I want all the records you have about dinosaurs. And this is what kind of requester I am. I'm an all other requester, and I'm sending it to you, and I'm citing both FOIA and the Privacy Act, and I await your response.
Yeah, I think all of that is really true. Going back to Jackie's point about 2 very different experiences with different agencies, I think one of the things that took me a while to kind of figure out about FOIA is most laws are fairly cut and dried sort of consequences and sort of how they're enforced. If you get a speeding ticket and you're getting a speeding ticket for 25 over, you're getting one fine. If it's for 15 over, you get another fine. FOIA is unfortunately much more of a negotiation. The law says you have to get a response within 20 business days. That sometimes happens, but a lot of times it's the start of a negotiation. You're entitled to a lot under the FOIA. Agencies are short-staffed and also reticent to actually release anything that might be damaging to themselves. And so what you're trying to do is figure out how do you actually get access to what you want with that specific agency. And I think one of the things that kind of really learned the last few years is that things that might work with one agency won't work with another agency. One agency might be very, very good at responding to, hey, I want a copy of all emails that mention X, Y, and Z in it. Another agency might say, we have no technical capacity to do that kind of search, so we'd have to do it manually, and it would take us 4,000 years to complete, or something like that. We've done requests where we asked for basic contracts between government agencies and Booz Allen Hamilton, for example. And some agencies gave us those contracts within a couple of weeks for free. One agency said it's going to cost us $350,000 and take several years. So I think it's good to know the law, but I think as Kel alluded to, it's a very basic law, and I think a lot of people, I know when I first started using FOIA and public records, I kind of freaked myself out. I kind of like spent days and days working on like the perfect letter. But I think much more important than sort of like legalese is just being clear about what you want, and then filing that request, right? If you don't file that request, or you take 2 months to file that request, it's either not going to come back or come back 2 months later than it otherwise would. And about response times, I think there was a lot of really good questions and discussion around response times. I think particularly for some of the requests that Kel's litigated, those are years and years long. I think there's also strategies to kind of get back requests more quickly. If you don't go for everything you might have initially asked for. Most agencies have simple and complex queues, and so if you ask for less than 500 pages or 250 pages of material, you're going to get that much, much more quickly than if you ask for 501 pages of material, depending on how that agency processes things. And I think there are cases where requests do take years and years to get back. That is the minority of requests. And I think sometimes those are the most important requests, but I think the majority of requests take months, sometimes weeks. Some agencies, we routinely get stuff back within a couple of weeks. Our average response time is 287 days. That's according to MuckRock's internal metrics. The federal agencies all put out their own reports that seem to come from a different universe, unfortunately. But I don't want people to think that you're not necessarily going to get stuff back. I sometimes tell people, file a bunch of requests. Some of them are going to come back quickly. Some of them are going to come back slowly. And so you don't want to sort of bet the farm on any one given request. Yeah, I think there definitely are some cases where FOIA takes years and years, but I don't want that to dissuade people from thinking that public records can be a useful resource, right? I think Jackie mentioned her amazing story about using FOIA to get back some really critical documents. Sometimes this can take months. I would definitely plan on months, but also, if you're in a situation where you don't have infinite time, I wouldn't give up on FOIA, because there's been times where I've gotten a lot of material and really important material in a shorter time frame.
Hey, Jackie, I've got an administrative question.
Sure.
Yeah. Hi, guys. Awesome. Thank you for doing this. When and how do you want us to ask questions? Like, what's the framework for?
So usually I open it for discussion after we've had the panelists kind of do a round robin, and then we will. And I see there are questions already queuing up in the chat, so I'm going to get to those next. But I was going to ask Jason if, from a reporter standpoint, do you see this any different than the attorneys are seeing this? And are there any maybe tricks of the trade? So I'm clearly hearing never say that you're a corporate employee wanting information. You always want to be a whistleblower or for the public interest, or maybe start your own newspaper. What are some of the maybe the tricks or ways to circumvent, I don't know if that's the right word, the years that it can take? Because if you're a whistleblower and you're trying to get information for your case, you're not the one setting the deadline for the case. The judge is usually setting those deadlines. So what could we learn from your experiences about getting at the information quicker?
Sure. So first, let me kind of offer what I tell other journalists, particularly journalists who work at Bloomberg, when they're filing a request, right? So I am trying to educate them on becoming experts at the way an agency functions, right? So many of the reporters who I work with, and many of reporters that I've spoken with, they'll file a request, say, with the State Department, and they'll ask for certain records, but they're sending it to the State Department. And the State Department's a massive, massive, massive government bureaucracy. So the person who is obtaining, or the records officer who gets the request and looks at it and is like, okay, well, this is overly broad and I have no idea where I should search. So the requester has already lost a month, just to get a response back. Then, you have to go through figuring out, where is the appropriate place to search. One place, you can do that, obviously, is on the government's websites or organizational chart, finding out what is the likely office or unit or division that has records. So I try to educate the reporter to make the request as targeted as possible. What is the name of the report? What does this subject line say? When was the email sent? Where is it stored? What's the name of the record keeping system? All of that is very valuable information. So prior to filing the request, because I think that at least as journalists, often the FOIA is kind of just thought of as like, I'll just fire it off. And that's fine if you know exactly where everything is, but it's just sort of, fired off and not really much thought or effort, going into, perfecting that request. So really understanding how an agency functions, where the records are stored, and for whistleblowers, how maybe there's another office that, may have relevant records or records that, are responsive or relate to what you're looking for. If you ask for records also on a very broad time frame, it's just going to take a long time. That's the reality. It will take a long time because the broader the time frame, the more, it's likely that they have, responsive, or, that responsive records may come up, and it could be voluminous. Now that's at least for journalists. And as far as whistleblowers, I think that's also very important, is to kind of make sure you come up with a time frame. When do you want this record search to begin? And when should it end? And keep that in mind, that if you are going very broad, is that the right move to make? So I try to keep it somewhat narrow, unless I'm suing, right? Unless I'm litigating and it's like, all right, I want everything and I'm going to go, file a lawsuit within a month anyway. So that's kind of really important. Know how an agency functions, what the organizational chart looks like, where records are kept, what is the record keeping system, essentially gathering that intel at the front end before filing the request. Then, essentially what I would say, and I don't know if it actually applies to whistleblowers, but oftentimes when, at least in the template, reporters often get responses from agencies that before they even have actually searched. It's not as if they're going through the filing system and saying, oh, well, we pulled out this and, you know, do you want this record? They're just doing a keyword search. They're going into FOIA Express and here's how many hits that we have. But I build into my template, and I instruct others as well, is to make sure you omit news clippings and press releases, because oftentimes the voluminous number of records that come back where an agency will say, well, we have 10,000 pages. I can guarantee you nobody is, you know, I wish people were talking that much on email because it would be great, but they're not. It's usually just press clippings and press releases, and you know, nobody wants that. So I always say omit those at the front end. But really, you know, like I said, what, you know, the most important thing is, you know, if you work at one of these government agencies, you know, you know how the sausage is sort of made, but it's important to kind of gather that intel at the front end to build into your request. And it's exactly what I do. You know, if I'm working on a, you know, on a FOIA request, I'm actually doing investigative work prior to filing the request, unless it's something that, you know, happened with a breaking news event. You know, let's say, you know, what's been going on with disinformation and FEMA. I'm using that as an example, right? That's just happening. It's very new. I know what I want. Can just sort of fire it off. But I think that what is important right now is don't think about how long it's going to take. Know that an agency on the federal level has, you know, 20, working days to get back to you. So that's about a month. They have that, right? They can also extend it 10 days, you know, for unusual circumstances, you know, whatever the hell that is. But you're already knowing that you have to wait a month. And the records officer, at least, you know, you ask for some tips. I try to befriend them. You know, they may hate me. I don't know. But I still try to befriend them because, you know, those are the people that you want to communicate with. That's who you want to open that dialogue with. If an agency comes back, records officer, and says, you know, because it's a first in, first out, and you're number 3,500 in the queue, see what you can do to get into a simple track, you know, versus a complex track. You know, unfortunately, the FBI is one of the worst agencies, you know, but they really are, because 0 to 50 pages takes, and that's 0 pages, by the way, 6 months. You know, once you get over that, a year. You know, a couple of thousand pages, 7 years. You know, you have to kind of accept that you are going to play the long game. FOIA is the long game. The only other alternative that you can try is it possible that if any other agency has the same records, can you file the same request with multiple different agencies to see who comes back first? Maybe try to, like, you know, blanket a couple. That really depends, obviously, on, you know, the individual, the situation. I don't, you know what it is, but I know that oftentimes, you know, just as an example, for FBI, you know, if there's some incident in DC, I'll file with FBI and Metro PD, right? I'll end up getting unredacted copies of some, you know, joint intelligence bulletin, and the FBI will redact everything. But I think it's very important to think of this as like the long game, becoming an agency.
Would a complementary agency, like, for example, in my case, the FBI showed up unannounced with the Bureau of Industry and Security, along with Department of Homeland Security. So I could file a request with the DHS and the BIS as well. Is that what you're saying?
That is what I'm saying. I mean, you know, Kel may want to chime in on that, but I mean, it sounds like there were two government, you know, representatives from two government agencies there. So,
yep.
then the question is who kind of owns the records. Sometimes you file the request with like the FBI, and it's like, well, we have to send these, a consult to the Bureau of Industry and Security because it's their record. So, Kel, do you want to offer some your 2 cents on that?
No, that was the main point I was going to hit, was especially if you're dealing with federal agencies. Oh, there will be requests that will go from FBI to BIS to DHS to BIS to FBI to BIS, and there'll be consulting a lot, and you'll get multiple copies sometimes where you'll release a page and it'll have like a line redacted that said this was sent to NCIS or something. And then you will get a different copy from NCIS that has that line released, but another line that was released by FBI saying, well, this was withheld after a consultation with DHS or something. And it's just, you have to sort of play mix and match and put together a Franken document in order to get something that actually looks original. But when it's different levels of government, that gets more interesting because, for instance, I had a case where it was a joint FBI DC police action, and the DC police kept trying to refer it to FBI, and I kept telling them, no, you can't do that. And I went in the DC, you appeal to the mayor's office. I said, they're not allowed to refer these documents to the FBI. They're allowed to refer them to some other DC agency. And I ended up getting them because even though they were FBI documents, they were in the possession of the MPD, and the MPD had no way to withhold them under the DC rules. And so you can have fun doing that if you can trigger that.
So, and I see in the chat, Heather a while ago now asked about extensions. Is there any mandate that they are allowed? They give you a deadline, and then she says, "What's up with that?" What is up with that? Are they allowed to ask for these extensions? Are they allowed to keep missing deadlines when they promise you things?
The second part, they're not allowed to ask for extensions because they never ask for extensions. They say, we're taking an extension, and that's it. Like they're allowed to, the 10 days that Jason alluded to for the unusual circumstances is just before you can file a lawsuit. FOIA is one of those weird laws where you don't have to exhaust administrative remedies. You don't have to wait for them to respond before you can go to court. If they don't respond within 20 business days, plus maybe 10 extra days, you can go to court. That is literally all that extension is about. They will take as long as they want to take. People have sued them saying this is not FOIA, they're not allowed to do this, and courts around the country say no, there's no penalty for just taking as long as you want to take, except you may have to defend yourself in court. There's no teeth to those, and so don't be that person who writes an angry letter to the FOIA office saying, you have to respond within 20 business days, according to the law. They will laugh at you and toss it at the bottom of the stack. They know that they don't have to respond. Now, that being said, you can get around that if you're not awful about it. One of the worst kept secrets in FOIA litigation and in FOIA is that a requester is not entitled to jump to the front of the line as a matter of law just because they filed a lawsuit. And if you file a lawsuit and try to tell the judge, make them process me first because I filed a lawsuit, the DOJ will make an example of you and cite all this case law that says you're not entitled to go to the front of the line. However, if you file a lawsuit and don't mention it, lo and behold, you're put in the litigation queue and you start getting records years before they would even start processing it because they want to get out of court. And so just don't be an ass about it. If file your lawsuit and wait for the records to start coming in, honestly. And that's where the lawsuits come in. Jason was talking about if you're ready to go to court. Being ready to go to court, however, is getting back to talking about how you write a request. especially if you're someone like who has a vested interest in getting the records you need, and you're not just like on some fishing expedition to see if you can dig up something. Writing a request that you can defend in court is different than writing a request that they might process out of good faith. And if you know before you file the request, I am willing to go to court on this, that's when you really dig into like doing your research, maybe talk to a lawyer, a FOIA lawyer, not a general practitioner, because they get rolled all the time by FOIA specialists in DOJ, and have it put it together. Because once you're in court, if you put a comma in the wrong place in your request, your court case is doomed, and you can't fix it once it's in court. And so your case will be dismissed, and you're free to file another FOIA request that was better worded. And so this is something that we have to deal with a lot. Is I have often had clients come to me, many of them whistleblowers, and say, I filed this FOIA request and I'm ready to go to court. And I'll read the FOIA request and say, we're not going to court yet. I'm going to file some new FOIA requests and we're going to litigate those because yours suck. Either you're going to get completely destroyed on when their judge gets involved, and it only takes adding another a second sentence to where you think the records would be or something like that.
Wow.
Well, thank you for that. Mine probably sucked too, so I'm forever grateful that whatever magic FOIA god saw my request and responded to it was very helpful for me, because I had no idea what I was doing. I really only wanted something very specific. So in hindsight, I only wanted records that mention these certain names from this time period to this time period. So I at least had that.
Hey, Jackie, when you said names, did you mention, like, are you talking about individual names? Is that what you mean? Like individuals?
Yeah, I knew, I was very suspect of who I knew said what they said about me. And I see Heather has her hand raised. She asked her question earlier in the chat. And I also see that Julie has put some really nice information in the chat. And I think Steve did too. So let's go to Heather. And then Julie and Steve, if you want to make comments, we'll circle back. But, North Dakota looks lovely.
Thank you. Thanks so much. I do have 3 pending requests, and in one of the requests, it was taking so long, so I asked, how can I get this expedited? Well, the FOIA officer gave me 4 conditions upon which you can request an expedite: exceptional media interest, lack of due process, safety hazards. So in my 3rd request, she said, but we can't grant you the expedite because you have to submit it at the outset of the request. Okay, so on my 3rd request, I said, here's my expedite request. There's been 11 media articles about this, and there's 40 documented due process violations. Can I get it expedited? And they said no, with no explanation. So then I said, how can I appeal your denial? And I'm about to I was waiting for this panel. Is the appeal effective? That's just options that are available to people, but I don't know if it's a good call. Oh, and the one other really crazy thing is the guy in charge of the FOIA office personally came out here and seized my computer in my whistleblower deal. So I'm alleging conflict of interest. I said, he came out here and was involved in a witch hunt against me. Oops, they screwed up and targeted me wrongly, but now he's in charge of my FOIA. He's got an incentive to withhold anything and everything because he was personally involved. This is all in my appeal letter, but so does expedite work? Is appeal a good idea?
Jason, have you ever had anything expedited? You're muted.
Jason, you're on mute.
Apologies. So, for expedited, yes, I have lots of things expedited, and it is really on the requester to make the case why, the agency should kind of, move you up and process your request in an expedited fashion. For journalists, it's obviously a little bit easier because I have to show, actual government activity, an urgent, news event or threat to life and safety. But one of the most important things that every journalist fails to do, I'm shitting on journalists here, and I'm one of them, is that you have to certify, your request and say, I certify this is true, et cetera, and sign it. And without that, you don't get expedited processing. That is one of the things, if you forget to do, don't do. And by the way, I'm not saying that you did not do that. I'm just saying that in general, those are the requirements. And every agency has, the regulations of what, constitute expedited, what their expedited regulations are and what's required. And some of them are different. I mean, I'll say that DOJ, for example, is pretty easy. But guess what? It takes longer to get them to give you records in the expedited processing queue than it does if you didn't get expedited. So that's how broken in some ways the FOIA is. So you really have to know how to kind of maneuver around that. But ultimately, it's on the requester to say, I would like this request, to be treated as expedited, and here's why, and so you're essentially making a case. I don't think you have to make necessarily, Kel may disagree, but I don't think you have to make a legal case. You have to explain this is, and what does it have to do with the federal government? This is so important, but what is that federal government activity? What will these records show about, the way, government, the government functions? But this is a kind of a really good example. And this is how you can utilize, in my opinion, the FOIA and wield it in a way where you're empowered. I mentioned the regulations. A lot of this is tedious and painstaking, and frankly, maybe boring. But reading all of that, reading that material, reading, what the regulations say, reading what the statute says, looking at some other requests, going onto the agency's FOIA, reading room and reading, some materials there. All of that is, you're just absorbing all that info, and it will empower you as you file the request. So if an agency does deny me expedited processing, frankly, I will appeal. But I'll also, and I know how to do it, and I know which agencies are just frankly rubber stamping, no, you can't have it. But I'll try to make a stronger case, or I will actually go and look at the stats and see, well, will I actually get it in an expedited fashion? And these are the things that you have to, consider when you are seeking that. So it may on paper say, hey, look, you can get it really quickly. But it doesn't work that way. I want to sound a positive note here. I filed a request a week ago. Was it a week ago? It was a week ago. A week ago with an agency. And I said, this needs to be treated, you need to treat this, grant me an expedited, processing on this, or grant this request expedited processing. And I made a strong case that I thought was 4 days later, I got records. 4 days. That's number 6 on my, on the list of agencies that have responded quickly. So did I get a voluminous set of records? No, I got exactly what I needed for that request in the agent. And that's how FOIA, that's when FOIA works, that the agency responded to, so it's a lot of, like I said, you're going to, in some ways, strike out many times, but when you get those home runs, it's that much more satisfying.
I looked at the link, the great link that you shared about the average processing time, and under expedited granted, it says NA. So
yeah.
Maybe they just don't expedite any.
And I'm sorry, which agency is that for?
Commerce.
Oh, commerce. Yeah.
And
Yeah.
to continue the positive note, although mine is a little bit less positive, but a lot sneakier. This does get to sort of what Jason was talking about being friends, being friendly with the FOIA officers, because they can help you and they can destroy you, and it's really up to their whim, which they want to do. And so you can get that by being friendly with them and being helpful. You can by doing something like, I'm only looking for these 2 documents. And somebody said in the chat, and Michael had talked about this, doing multiple requests. I'll often do multiple requests, and I'll be explicit about it. And I'll say, Jason Leopold #1. This is for a copy of the report into Jason Leopold of this date. And then I'll say, now follow a different request to Jason Leopold #2 and say, this is for all records about Jason Leopold, excluding what you processed earlier. So you don't have to waste time, because I'm nice that way. And I'll get the first thing fast and the second thing slow. You can also do this by not overtly threatening them, but by being someone they think is threatening. And by that, I mean by being a Jason Leopold or by being a lawyer. You would be amazed how, especially with whistleblower cases, be amazed the radically different response times you get if the records about Jackie Garrick were requested by a reporter she was working with or her lawyer versus Jackie Garrick saying, Jackie Garrick, request this. They take lawyers seriously, they take journalists seriously. So if you have a pet journalist or a pet lawyer who can put it on their letterhead, that will get you through a lot of the log jams.
Yeah, you just went right to one of my questions about, sort of looking for a godfather and doing all of this, like partnering with a reporter who is going to do a story, even if it's, it doesn't have to be Bloomberg, although Bloomberg would be great, Jason. It could be even your local, the Daily Telegraph, local community newspaper, or even an online something that has a reporting presence. I do think having that partner who has done this before, who is not, shooting in the dark trying to get lucky. And of course, hiring an attorney, working through a law firm is always probably your best bet, because, and that takes me to my other piece, is the difference between FOIA and discovery. When would you as an attorney do discovery, and when would you do FOIA, or would you do both?
I do both. I'll get yelled at. FOIA is not meant as an alternative to discovery, but there's nothing prohibiting it. And I will often do sort of what you did for a whistleblower client and say, discovery, they're jerking us around on discovery. I can file a FOIA request and at least have that plugging away in the background. And sometimes the FOIA office doesn't talk to the OGC, Office of General Counsel, and you'll get something through FOIA that they didn't give you through discovery, and Yahtzee for when you bring that up to the judge. And I'm not saying because it's incriminating. I'm just saying, like, it was clearly responsive. They're playing discovery games, Your Honor. You should sanction them. They operate by different rules, though. So, for instance, in FOIA, I'll go back to in discovery. In discovery, if something is, say, privileged, attorney-client privilege, or deliberative process privilege, or something like that, you can get over that by saying, I really, really, really need it. And a judge can say, yeah, the need outweighs the privilege. That doesn't happen in FOIA. And so if they say, because the rule in FOIA is, if someone somewhere could say it's privileged, it's withheld. There is no balancing test. So you can get more in discovery for challenged documents, but discovery is also limited to whatever the agency thinks is relevant to the case, whereas you can go on a fishing expedition with FOIA and find stuff that they don't think is relevant, but you think is relevant. And you can use them to sort of piggyback on each other and leapfrog over another. Michael has 1,000 clients that are always requesting records for their own benefit for whatever they're doing. How have you dealt with this, Michael?
Yeah, I mean, I think FOIA is all about negotiation, and so I think using it as a tool wherever it makes sense. I think one thing, and I have to hop in just a few minutes. So one thing I did want to say, and I think this was a good lead-in, is in terms of lawyers, I think being mindful about FOIA there can be retaliation. I think, Heather, your story about sort of the FOIA officer also being somebody you've had a run-in with the past. Like FOIA is not sort of like an independent, autonomous agent out there. You know, these are people, and I think these are, for the most part, people who are professional and take their job seriously. I've also had a FOIA officer pretend to be an FBI agent and threaten to arrest me. But I think one thing, particularly for whistleblowers, I've also seen whistleblowers include national security information in their FOIA requests, and then they got court-martialed in one case. And so be careful. Like, if you're the only person who knows some information exists, and that is classified information, if there's potential retaliation, if possible, talk with a lawyer. Kel is an amazing lawyer who's been at the intersection of not just FOIA, but employment law. So I think he's particularly good at some of these issues. I am not a lawyer, as he mentioned earlier. But if, just be thinking through, like, making sure you are protecting yourself, because the FOIA, very rarely, but I have seen FOIAs cause blowback in some ways. And so if I can mention one other resource that might be useful for whistleblowers on the legal front, is Free Expression Law is a network of legal clinics around the country that often are located students. And so they are legal clinics that are run by real lawyers, but a lot of student attorneys as well. That's another potential resource, especially if it's not time sensitive, because they do run on academic calendars. But I do recommend, even if you can't afford a lawyer, finding ways to connect with lawyers. I do recommend that in particular here. And if we ever meet up again, I'm happy to tell you the story about the FOIA officer who went completely off the rails on me.
So, Michael, I'm clear that Jason worked for Bloomberg and Kel is an attorney. What's your role? We never really did. Wasn't clear on the introductions. Like, what do you do?
I founded an organization called MuckRock. We build a variety of journalism and transparency tools. I knew nothing when I started MuckRock, and I'd filed 3 public records requests, and 2 of them had gotten nothing back. And so, but since then, we've been around for 15 years, and we also have lots of public examples of FOIA requests. So if you're like looking for language, I see people share long templates. I see nonprofit organizations who I love, and so I will not call out by name, but they'll share like 10-page FOIA requests that they submitted. I do not recommend that for most requesters. And so we have lots of examples of successful and unsuccessful requests that you can browse and kind of look for ideas.
Thank you.
Julie, Steve, did you want to make any comments? I've seen there's a lot going on in the chat. Tracy was asking some questions. Kel, you mentioned that it's retaliation for filing FOIA requests is totally cool and totally legal. If you work for an agency, you shouldn't FOIA your own agency. Is that what you're saying?
Well, no, I'm not saying that you shouldn't. I mean, you kind of need to, especially if you're a whistleblower. But the employment lawyer in me comes out and says, but retaliation for filing a complaint is protected. Retaliation for doing this thing is protected. Retaliation for filing a FOIA request is not protected. Filing a FOIA request is not a protected activity. And so they can totally say, you're a troublemaker, I'm sending you to Alaska because you keep filing these FOIA requests. And that the you can maybe bring it up in an MSPB if you have MSPB rights, but if you're say in the FBI or State Department or the intelligence community and you don't have MSPB rights, they can do whatever they want to you because they haven't violated Title VII, and they haven't violated any kind of whistleblower retaliation statute because filing a FOIA request is not protected. And in fact, I had a client. Sorry, no, Brad Moss, a colleague of mine, had a client, and he was an expert for me in a lawsuit, and if I get mixed up, who filed FOIA requests for documents he knew the agency had because he had processed them as part of the historical collections division. He had prepared them for public release, and his superiors decided we don't want these released, and he really was a true believer and wanted them released, so he filed a FOIA request for him, and they yanked his clearance for it. And there was an ongoing fight for a year or so over whether or not they could yank his clearance. The agency finally relented and gave him his clearance back. But they were saying, "Oh, the FOIA officer is not cleared to know that these articles exist," or something. Going on to what Michael was talking about be careful what information you include. I was like, you mean the FOIA officer who's an original classification authority who can decide whether or not to release them can't know that they exist? And yeah, it was awful.
Julie, did you want to add about, I see in the chat you said something about you could chat about retaliation. Did you want to, and I know we're getting to the top of the hour, so if you have something you wanted to add?
Sure, I don't mind. So I was going to say one of the overall things I would say about the legal statute regarding retaliation, and it's different if you're a federal government employee and you're protected under the False Claims Act in your case, or if you're filing as a key TAM relator. So as a key TAM relator, the legal statute currently does not recognize retaliation after you've been terminated from that company or that contractor. So you can be retaliated against, and I would just say, get ready. So just like Kel mentioned, I've lost my clearance. I was trying to think. So I lost my clearance 9 years after I became a whistleblower, and also after the government settled my case. So it's kind of interesting, I guess, the retaliation, but there are different legal statutes that hold up depending on what circuit or what federal court or what state you're in. So if you're in the 6th Circuit right now, you have a little bit different protection. If you're in the 10th Circuit, which is where I am, I'm so sorry, everyone, I made bad law. So, and I didn't make it, I should say 3 judges made it in the 10th Circuit, and probably not what we would say, but to focus on FOIA, my advice, and I'm someone who used to process FOIA requests and Privacy Act of 1974. Both of those legal kind of caveats work for most people. I would combine them in your request, not just FOIA, but the Privacy Act of 1974, even though it might not seem relevant today in 2024, it is something that those of us who are processing certain information do take into consideration. So I used to work as a contractor for United States Office of Personnel Management, and I used to take a look at these a lot of the time. And I would say the biggest thing that I would advise is be detailed, add in specific information, especially if you're writing to the agency that you used to work for. So use the name of databases, use the name of systems, use, those acronyms that you're saying, I want a copy of this. I want a copy of my security record from, let's say, JPass and another database or whatever it is. Don't be afraid to be detailed in your request. And also don't be afraid if the FOIA office comes back and says to you the first round, we didn't have anything, and you look back and notice that you didn't say. So I submitted a FOIA request to ODNI for my security record. I said, in all databases that it would be in. I didn't say the name of one because I I felt a little bit hesitant in saying the name, and it came back and they said, we don't have anything on you. So of course I knew that it was in that database. I think that's one of the things, is making sure that you know what you're looking for, or you know what that agency holds, or you've reached out to someone. It could be, say, a former security officer, HR, or just, you know, someone that you worked with that might be able to guide you. Because I will say, people in other positions do request information. They can guide you on what some of those database names are. So I resubmitted my request for my security record, and in that I actually named the database, and she got it back to me probably within 14 days, because I felt like in some ways I had kind of called out that I knew there was a record in such and such database. So when the second request went, I would say that's when it kind of moved quicker. So I would say, don't be afraid to submit multiple FOIA requests if you can, multiple agencies, because there is an ODNI, which is, you know, the Office of the Directorate of Intelligence, which has oversight over multiple agencies. So if you have an agency that falls under that group, they have their own FOIA office. So if the agency is not giving you anything, don't be afraid to go to, say, you know, like an oversight agency like ODNI, who does have a FOIA office and has some type of jurisdiction over the records and things that they keep for certain agencies. So I think, you know, also don't be afraid if at first they say no. Keep submitting, be more specific. It's okay to submit multiple FOIA requests. And then my other part would be, yeah, nothing in my world was ever expedited. And so I would say that plan to proceed with your attorneys and on your case without having that information. Obviously, you can show anyone all the, you know, number of requests you've sent, all the attempts you've made. Judges will look at that. It will be in your file. But yeah, I would say sometimes you can be held up for a very long time in this bizarre back and forth, trying to get what you think you need, especially if you're someone that works in the classified world, or if you're someone that works in national security, or for certain agencies. It just is not really the most friendly environment. But I would say there are experts out there who can help you form the words and put together those phrases, and kind of, you know, I think the verbiage and language is really important. And I also think it's important for you to know what you're looking for, what you think exists, and where you think it exists for whatever company or agency, I guess, that you're requesting from. And you can ask a multitude of different people. I think there are many of us who have a lot of experience submitting FOIA requests, and even Privacy Act of 1974, utilizing those to get records, even though I think my attorneys, when I first wrote my first one, were kind of like, wow, this is way too long. And I said, trust me, it's probably not enough. And so, you know, I think it just, if you know your agency, you know what you need, don't be afraid to ask for it. The worst that can happen is they'll come back and say no, or they'll just redact it all. And I would say, even in redaction, there has to be a reason that you're redacting. So if you're going to redact half of my record, you have to tell me, is it because it's classified? Is it because it exposes, you know, potential sources? Is it operational? Why is it redacted? So there are also legal rules on redaction. So I do think sometimes someone takes that black marker and you just get, you know, on the top of your page, it says 1 through 750, and you're just looking at someone's Sharpie that went through it, like you know, every single word except for, you know, it almost looks bizarre at times. But I think there are also rules for how redaction works too. So it's sometimes good to have, I guess, that legal component, or someone who's an expert in doing some of these requests.
Julie, thank you so much I think that was a great summary. You know, I know we're also over time, so I don't want to hold people. Steve, did you come on because you wanted to add something quick?
Oh yeah, I just wanted to know if anyone had any experience trying to surpass the exemption 7A with regards to a FOIA request, where they come back and say, the information that you're seeking is currently under law enforcement activity. And if we release it, that would jeopardize the enforcement activity results.
Kel, would you mind taking that offline? Can I connect
Sure.
the two
Well,
of you?
it's a short answer.
Okay.
Wait until the activity's over, then resubmit. Short of that, you're hard pressed to beat that because agencies get a ton of deference even when you litigate on that.
Right. Okay. Thank you.
The one thing I would add to that is what I always tell the agencies is, you know, sometimes often I get a blanket 7A request, and you know, FBI is kind of notorious for that. One thing that, you know, they're supposed to do is kind of do a document by document search before they just issue a blanket 7A. I would encourage everyone to become familiar with the FOIA Wiki, which the FOIA Wiki is a fantastic resource. It is maintained by the Reporters Committee for the Freedom of the Press, but it applies to everyone. And it has great information there on how to challenge some of the exemptions by citing, you know, it cites case law, right? So it's just, again, another great tool to just use to empower yourself. I apologize. I have to jump.
Yeah, we're over.
My email is, you know, on my LinkedIn. Anyone can reach out if you have any questions. Jackie, it's great to see you. Kel, great to see you. Look forward to catching up more in depth one of these days. And thanks again.
Thank you for jumping on this. All right.
Thank you. Bye, everyone.
I really do. I appreciate, and you know, I know we are definitely over. Cal, thank you for hanging in there with us. We will be reconvening again next month, November, same time, same place. We have got a really interesting special guest with, oh, his name just flew out of my head, Burling Law Group. I remember his last name. We are going to be discussing the lawsuits that have gone on at the Department of Veterans Affairs when a veteran has died by suicide, and the families have been working with whistleblowers, with employees, to bring cases because the VA isn't living up to its standard of care. So Amy Neiderberg and Mr. Lawyer Bertlinger, we will be announcing that upcoming roundtable for November here shortly. So keep an eye out. And thank you again for everybody who has participated and stayed on this long. If you need to connect with anybody, if you didn't do that already in the chat, send me an email and I'll do my best to make sure everybody. Peter, thank you. Oh my gosh. I wanted to call him John and I knew that was wrong. Thank you, Paul. Peter Bertling is the attorney who will be with us next time. Whew. All right. Thank you, everybody. Have a good evening and I will see you next month. Thank you, Julie, for being with us. And it was good to see so many familiar faces. Have a good rest of your month. Bye.
Thanks, Jackie.